Hi, everyone. Welcome to another great session. Hi, hello. Hope you're fine. Hope you are good. You're welcome to Lawyers Info Hub. It's a pleasure to create content on this platform. We are here to support the legal education. We create law content that will help you in your practice, help law students, help young lawyers, even help those who are already old in the practice to refresh their memory. Yes, we believe in having the requisite knowledge you need to excel. We believe in knowledge, we believe in hard work, we believe in knowing what to do, and we believe in excellence in our practice. So today we're looking at subpoena. Yes. Many at times, many people confuse subpoena with summons, court summons. They are different things. But today we're looking at subpoena. We want to look at the types of subpoena. We're looking at the content of a subpoena. We're also going to look at how to take a witness today, and we hope that, and I do hope that you enjoy the class today. So, what is a subpoena? A subpoena is a document, it's a formal document issued by a court commanding a person to appear before it to attend to the court at a given date, either to give evidence or to produce a document that is in his or her custody. Now, because it's a court subpoena, it is mandatory that the person who is being subpoenaed appears. It's a mandatory invitation for you to appear. I know when one refuses to appear, content proceedings can be issued, commenced against that person. It's also very important to note that when subpoenas are being served on parties, um, the person they're issuing it must be properly, noted. There's no need to have any mistake. There's no need for a mistake. Yes, because when there's a mistake as to the person you're addressing it to, that can cause a delay or cause that person you desire not to appear. So you have to ensure that the right person is subpoenaed, you give them the right name, the address, so that the subpoena, which is the court document, will have the proper particulars. Now there are two types. There are two major types of subpoena. We have the subpoena dus tecum and the subpoena ad testificandum. Now, first one is subpoena, this tecum. It is used where you have a document in the hands of an adverse party and you want that person to come and produce that document. Now, if in the course of conducting your matter, there is someone who has a document that you need, and is not a witness in that matter, you can, you know, by the orders of the court, a subpoena can be issued against that person to come and produce that document in court because you need it. Now, um, it is very important when you are handling a matter to, during your pre-trial conference, to ask your witness, are there people who can testify? Yes, even though they are not witnesses, they are per se, in the sense that when you are filing the originating processes, their witness even on oath was not filed. But you can list in your list of witnesses that these people will be subpoenaed in the course of the matter. So that is why sometimes when in a process you will see some names listed as witnesses to be subpoenaed. So you see, it shows that this particular party is going to subpoena witnesses in doing trial. So that way, during trial, they cannot issue subpoena, the court will sign it, and those people will now come and testify. Now, then subpoena ad testificandum is a type of subpoena issued to someone. It is used to secure the attendance of an adverse party to testify. So ad testificandum is about the party coming to give testimony to testify in that suit. Why the subpoena dus tecum is used just for the person to tender document or to bring a document in his or her possession. Now, there's a third leg or the third arm or a third type of subpoena. Now, you want the witness or the person to come, not just to come to court to testify, to also tender a document. So now the person is doing two things in one. We are securing the person's attendance to court, and the person is tendering a document. So the subpoena to be issued is now the subpoena, dus tecum ad testificandum. So the person is coming in a double capacity. He's coming to testify and he's coming to tender documents. Now, a species or a kind of subpoena ad testificandum is habeas corpus ad testificandum. Is a species of subpoena ad testificandum. So this habeas corpus ad testificandum, it is used to compel when control of prisons or a correctional facility to produce somebody in their custody at a given date in court so that the person can testify in the matter and then return that person back to that facility thereafter. So if peradventure you are doing a matter and the person you want to testify is in prison, so these are this habeas corpus ad testificandum is a kind, a species of subpoena ad testificandum issued to the Controller General of a correctional facility or a prison center to produce a prisoner in their custody for the purposes of testifying in a matter. Thereafter, the person will return back to that facility. It is also very important to know that as much as you can subpoena people to come and testify in your matter, the person to be subpoenaed must be a competent witness and a compellable witness. So that aspect of compellability and competence must be factored into, must be considered when you are issuing a subpoena. Now, our various rules of courts, the Federal High Court rules, the State High Court rules, all of them have, you know, there are rules regulating subpoena. So you have to depend on the court you are in, and that requires you're issuing the subpoena. So you have to look at what is the rules saying about subpoena. Now, in some rules, you see that um, if it's someone that is coming to testify, the rules will provide that you find a witness statement on oath of that person. Now, so it's very fundamental that you look at the rules to know what is the rules saying concerning this subpoena I want to issue, so that you do it in the right way. So there won't be issue of any objection whatsoever. Yes, there's no issue of objection whatsoever on whether I got it right or did not get it right. Our Evidence Act also makes provision for subpoena. So so it's also very important that you note the identity of who you are subpoenaing, the person's address, because this is part of what will be in the subpoena, so that it will be served on that person without any form of a mistaken identity. Now, in our rules, if you check the back of your rules, you see the precipice of how a subpoena looks like. What is the content of a subpoena? So you follow that recipe to produce what you want. It's also very important to note, is this a federal court? Is this a state court? This knowing whether it's a federal court or a state court determines in whose name you're making that order. In sense that when you are the recipe, um, let me just explain what I mean. Now, if it's in a state high court, you know that it's the governor of the state that is the chief commanding officer that will have to you're going to issue that subpoena in the name of that person, commanding that particular individual to appear in the name of the governor. Now, it is a federal court, you know, it is the name of the president, that you're going to use. So, it's the content, looking at the content of a subpoena, you head it the way you head your process in the High Court of so state, in the so judicial division. You head it, put the suit number as though you're preparing the process, put the name of the parties. Now, on top of that, before the heading, which is in the court of or in the High Court of, before that, you have to put the form. Sometimes it will be from, depending on what it is in your rules, from 20 something, 27, depending on the rules. So you look at the back of the rules, you see precipice where it is, on you see subpoena. So check what the number of form it is, then you put that form number, then you now head this subpoena, you add testificandum, subpoena dus tecum, if it's subpoena just they come at us, whatever it is, if the person is coming to do the two things at the same time, you heard it. Now put the order under which it is brought, because I told you that each rules of court makes provision for subpoena. So you check which rules is it, order 10, rule order 32, rule whatever. You just put it there under bracket. So even the precipe at the back of the rules will show you just like a precedent which you will now use to replicate what you want. Now, after you have put down the names of the party, you now say to who is the person you're issuing it to Mr. AAA, to Mrs. XYZ of the address of this person is very, very important, because when you put the wrong address, the bailiff who will serve can make mistake. At the end of the day, the subpoena doesn't get to the right hand. So you must know the address of the party you are securing the attendance, or you're mandated to appear to testify. So, so you put the address. Then under you now say you are hereby commanded in the name of the governor of so state, if it's a state high court, or if it's a federal court, national, if it's a federal court, national industrial, is a federal court, federal high court, and you command in the name of the president to appear before this court at, you put the name of the justice, honorable justice, so court, sitting at so on the dash day of dash at the hour of 9 o'clock in the forenoon, and so from day to day until the above cause is tried, to give evidence on behalf of so. If it's to tender document, you say to tender document on behalf of the claimant, on behalf of the defendant. You now put the dated, the dash day of dash. You know that it has to be dated. You know, now that is the main thing, and after the data under it is now where you put a signature column for the judge, because the judge has to sign this subpoena. That is, once it is authenticated or signed by the judge, it is now valid. Now, there's another one that have to be in front before this other one I spoke about. It's also a form of precipice. That is now the seal writ of the subpoena. Is the subpoena ad testificandum or subpoena dus tecum. You know, you still head it as form of precipice. You now state still the name of the person you're issuing the subpoena to, dated, put your date. Then this is, you now put down your name, your office name as the signature aspects, as you do in the process. You know, this one now there's no for service on. Rather, you're serving the person you have named, this that has that the name is on the subpoena. So the first page of your subpoena will be the seal writ of subpoena. And is it ad testificandum? Is it just they come on behalf of the claimant, on behalf of the defendant, then on Mr. Mrs. XYZ of number 10, dated this dash day of dash. You put the date, you now put your name, your office address, who you are representing. For this part, you put your seal as a legal practitioner who is issuing this subpoena, then you sign. Now, the second paper or the second document is now the one I talked about, which is the form. So depending on what your rules say, you see that the precipice is also on the form, on the rules, as I stated at the back of your rules. Check out your precipice or the precedent. You see that your subpoena is one of those forms to be on the back of the rules. Now, this other one, this second page is now where you now state that the person you're referring to, who is to be subpoenaed, is now is commanded in the name of, is it governor, is it the president, you know, just like I earlier, stated. You put the date, then the judge will sign. It is only that second one that the judge will sign. The first one is just where you put your name as a legal practitioner who is issuing this subpoena, then put your seal as it ought to be. Then the second page is where the judge will now sign. Remember that even before the judge signs, you have to go and file it. It is filed like a process, then it is sealed in the registry, then you now bring it to the court, submit to the court will look at it. If it's approved, the judge will sign. And when the judge signs, now a copy will be given to you, the original will be with the judge. It is that copy that you now facilitate service using the court belief or to serve this person. And once the person is served, the proof of service before the court, if there's a disobedience to this order, it's not an order of court for the person to appear. It is mandatory that the person appears on the day name, because the day the person is supposed to appear has to be there. That's part of the contents of a subpoena. The subpoena will have the the name of the parties in that, like the suit, the name of the parties, the suit number, the court that the person is appearing, the name of the judge the person is appearing before, the date the person is supposed to appear. If there's time, the time the person is supposed to appear, the name of the party, the address of the party. Then the signature column of the judge will be properly signed to show that it is a judge that is have signed it and have proved it, and you are being commanded either in the name of the governor or in the name of the president to appear on that day. So when a person is served with a subpoena, these are the things we have to check out. Is it properly issued? Is it properly issued? Sometimes when it's not properly issued, that is a point for objection. A subpoena can also be set aside. Now, a subpoena can be set aside if it's vague, if it's frivolous, if it's embarrassing with no beneficial purpose. And sometimes between people raise objection on a subpoena, saying that what this person is coming to say is a private matter of a party. Sometimes objections can come up. Is frivolous. The evidence of this person is of no beneficial moment or purpose. People, or it is not even properly issued, or it was not served. So these and many more are the points of objection that can be used by defendant or claimant, depending on the instance, to counter the competence of a subpoena. So it is very important to know that a subpoena is the attendance is mandated. So once a person has been served with a subpoena, it is expected that the person appears in court on the day named. It's also very important to note that when a supreme witness is now in court and you are the party who is requesting that person so you will conduct trial for that person. Just like I stated earlier, you have to check the rules. If you need a person to a witness statement on oath to be filed for that person, then a witness statement on oath has to be filed, and the person will have to, sign the deponent session before the commission of oath at the court registry. You file it in court. So on the day of trial, the supreme witness will now enter the box. You now conduct trial as a normal witness, because the person witnessing on oath is already there. If there are documents the person needs to tender and the person is also testifying, you would have pleaded or stated those documents in his witness statement on oath. So as the person you're conducting the examination in chief, the person is identifying those documents, and those documents have been admitted where there are no objection against its admissibility. So that after the person has you have conducted the witness, the examination in chief, the other parties now have the opportunity to cross-examine this party. Because yes, once a person has gone to give evidence, the evidence must go through the fire of a cross-examination for the veracity, to ascertain the veracity of the evidence of that party, of that subpoenaed witness. Now, if it's a witness who only comes to tender documents, not going to come to testify anything, so there's no need for his or her witness statement on oath. It just comes, drops the document and goes. So you see, sometimes you see people the officers of some government parastatals are being subpoenaed. Maybe officers from the Surveyor General Office just come and maybe come and tender the composite plan, come and tender the land certificate, come and tender this. That some government parastatals, you see, they are being subpoenaed. The officers are being subpoenaed to come and maybe just tender a document. This is, for example, other people can also be subpoenaed. You just come, tender the document, no um, testification, testimony of any sort. You just tender document and they will go, and that ends it. Whereby for those who are going to testify after the examination in chief, they will also have to be cross-examined. So both parties will have a fair share of everything because I mean the evidence will be cross-examined to ascertain the veracity, and that is it. And that will be the end for that person. The person who has satisfied that obligation, that commandatory obligation, and the person is being discharged. So another video, I'm going to talk about court summons, because a lot of people have confused court summons with a subpoena. So I've been able to discuss or define what a subpoena is. So there, just let me mention like two cases for you on subpoena. You can check them out. You can take the case of Ibrahim against Ogunleye. It's a 2010 Law Pavilion Electronic Law Report 4656. It's a Court of Appeal decision. Also, me, they ran against Patricia. It's a 2010 Law Pavilion Electronic Law Report 9160. Is also a Court of Appeal decision. All talk about the subpoena definition, their differences. So go read them up. And there's so many other cases that talks about subpoena, the types of subpoena, how to the content and what it portends. So, friends, it's been a wonderful class today. So, we've learned about subpoena, we've learned about the types of subpoena, we've learned about the content of the subpoena, the fact that you have to even file it, pay the necessary statutory fees, has to be served on the person who is being named, and yeah, the person is coming to testify. The fact that the document, if the person is going to also testify, tender document, the document should be pleaded in the witness statement on oath so that to be easy for you during trial, during examination in chief, so that these documents can be tendered properly. If there you need to lay a foundation where necessary, those foundation needs to be laid so that your document can be proper and admissible in its right form. Then the witness will now be cross-examined by the other party before the witness can be discharged. So subpoena is one very potent tool a party can use, and while trying to prove your case or trying to settle a dispute in court. If you're yet to subscribe to this channel, please do hit the subscribe button, share this video, and like same. If you want to drop your comment, there are questions you have in this class, please drop them. It will receive answers and response. No, immediately. So if you feel you have lost students around you, mentors, mentees, people around you that need to see this video, please do them a favor by sharing this video to them. We are doing this out of passion. We're here to support the legal education in Nigeria, in Africa, all over the world, so that people can always have a place they will come and get more knowledge, because when we stop learning, we start dying. We have to keep learning every day, refreshing our memory when you need it, for us to excel in our practice. So it's been a beautiful time. It's been a beautiful moment. I love what I do, and I'm happy you're gaining knowledge from this. Do take care of yourself and see you next time. Know that you can always be the best. Let no one they distract you. Don't allow your goals to be as dreams. Bring them to reality and let it work for you. Do take care of yourself.